Very good day to all of you. The Bombay High Court has recently passed a very important order in the matter of transition of education cess, secondary education cess, and other cesses. The order is very important. So we will see what are all the implications of this order and we will have an understanding about this order. It is in the case of Godrej Boyce Manufacturing Company Limited versus Union of India. See, section 140 of the CGST Act that deals with the transitional provisions. Various credits. Once GST has been introduced, there should be a provision for carrying forward the credits availed under the old law. Section 140 contained a detailed mechanism which is applicable for different circumstances. Subsection 1 deals with wherever the credit has already been availed by a taxpayer and the balance is lying in his last return, that is the return for the month of June 2017, whatever is the balance credit available, that can be carried forward to the GST regime. That is what subsection 1 provides for. See, this education cess, secondary education cess, and the Krish Kalyan cess, these were all eligible for the benefit of Senvat credit under the Senvat credit rules 2004. With the only restriction that a credit of education cess should be used only for paying education cess on the accessible goods or the taxable services. Similarly, secondary education cess can be used only for secondary education cess, like that. In 2015, the education cess and secondary education cess on excise duty, that is on the manufacture of accessible goods, that has been removed. And subsequently, even in service tax also, these cesses have been removed. But the balance of whatever education cess and secondary education cess credit, which has already been taken, that has not lapsed. There are no legal provisions lapsing the balance of credit of education cess and secondary education cess. And in fact, when these cesses were removed from service tax, there was a budget speech where they said we are aggregating everything. All cesses, everything is now added, and the service tax rate is also enhanced to 15%. So it has got subsumed into the service tax rate. So there was balance of education cess and secondary education cess. Similarly, Krish Kalyan cess also on 30/6/2017 in the hands of manufacturers and service providers. Now the question is whether this balance of education cess credit can be carried forward by filing the Tran 1 form, and this can be used for payment of central tax liability. That was the moot question. There was a Madras High Court judgment on that, a single judge bench, and subsequently the decision was also overruled by a division bench. That is one part of it. If we read section 140 subsection 1, a registered person other than a person opting to pay tax under section 10, that is composition, shall be entitled to take in his electronic credit ledger the amount of Senvat credit carried forward in the return. The word eligible duties was subsequently added. We will come to that later. Carried forward in the return relating to the period ending with the day immediately preceding the appointed day, that is 1st July 2017, furnished by him under the existing law in such manner as may be prescribed. This within such time was also subsequently added. See, this was the provision which says whatever is the balance of Senvat credit which is available on 30th June 2017 can be carried forward. So it does not say anything about whether education cess can be carried forward or not. So everybody believed that education cess, secondary education cess, and Krish Kalyan cess, the balance which was lying in the return as on 30th June 2017 can very well be carried forward by filing the Tran 1 return. This was the understanding. This is subsection 1. So various subsections of section 140, we have to understand section 140 very clearly to understand the High Court judgment, Bombay High Court judgment. So every subsection of section 140 dealt with a different situation where transitional credits were allowed. Subsection 2 deals with unavailed portion of capital goods credit. That is, under the Senvat credit rules, capital goods credit can be taken only 50% in the first year. Balance 50% can be taken in the next year. Suppose in 17-18 some capital goods were purchased. April, May, June, first 50% credit has been taken. The remaining 50% can be taken under subsection 2. That is subsection 2. Subsection 3 deals with a situation where a person is not eligible to take any input credit under the old law. He is manufacturing exempted goods, so he cannot take any Sen1 credit. He is providing exempted services, so he cannot take any Sen1 credit. So like that, there are certain people who could not take Sen1 credit for the inputs. But after GST was introduced, they got registered, they are going to pay GST. So they should be given the credit of the taxes paid, that is the duties paid on the inputs which are lying with him on 1st July 2017. It may be input as such, or it may be contained in the work in progress, or it may be contained in the finished goods. So subsection 3 deals with allowing credit for a person, the credit of duties paid on inputs which are lying in stock as on 1st July 2017, if that person was not eligible to take such credit under the existing law. This is subsection 3. Subsection 4 is a combination of 1 and 3. That is, I am a manufacturer of both taxable goods and exempted goods. For taxable goods, I would have already taken the credit, a part of which may be lying in balance. So that I can carry forward under subsection 1. As far as the exempted goods manufactured by me, I was not at all eligible for taking any credit. So for that, I can take the credit under subsection 3. So it is a combination of 1 and 4. Subsection 5 deals with inputs and input services in transit. That is, the goods were dispatched prior to 1/7/2017. Excise duty was also paid, but the goods were received after 1/7/2017. Similarly, on a service tax was paid before 1/7/2017, but I received the service after 1/7/2017. So those situations are covered by subsection 5. Subsection 6 deals with certain cases where there were certain special schemes like air travel agent, like that, where tax will be paid under a different scheme. Instead of paying service tax at the usual rate, some nominal rate will be fixed subject to a condition that credit cannot be taken for the inputs. So those people, once those schemes are not in force under GST, they become eligible to take credit for input. Whatever is the input lying in stock, contained in work in progress and finished goods for those category of persons. Subsection 6 deals with such particular situation. So these are all the various subsections of section 140 which are relevant for our discussion today. Subsection 1, the balance as per the last return. Subsection 2, unavailed capital goods credit. Subsection 3, any person who was not eligible to take input credit under the existing law, now he can take the credit for the inputs lying in stock. Subsection 4 is a combination of 1 and 3. Subsection 5, inputs and input services in transit. Subsection 6, certain specified category of persons who were not eligible to take input credit earlier, now they can take for the inputs lying in stock. So this is very important. Now, there were two explanations under section 140. Two explanations. The explanation 1 deals with what is eligible duties. Wherever the word eligible duties is used in section 140, this definition will apply. So what is eligible duty for the purpose of subsection 3, 4 and 6? These 3 sections uses the word eligible duties. So it becomes important to know what is eligible duties for the purpose of subsection 3, 4 and 6. So this explanation 1 defines eligible duties. It says AED, GSI, that is Goods of Special Importance Act, CVD, SAD, AED, TTA, that is Textile and Textile Articles, Excise duty, National Calamity Contingent duty. So these are all covered in the definition of eligible duties for the purpose of subsections 3, 4 and 6. What is subsection 3? What is subsection 4? What is subsection 6? We have already seen. So eligible duties means the following 1, 2, 3, 4, 5, 6 duties in respect of inputs held in stock and inputs contained in semi-finished goods or contained in finished goods which is in stock on the appointed date, that is 1st July 2017. This is explanation 1. There is another explanation, explanation 2. This defines eligible duties and taxes. That is the expression used. This expression is used in subsection 5. So there it is defined what is eligible duties and taxes: AED, GSI, CVD, SAD, AED, TTA, excise duty, NCCD, and service tax. In respect of inputs and input services received on or after the appointed date. See, subsection 5 deals with allowing transitional credit for the inputs and input services in transit. Inputs and input services received after 1st July 2017, where old taxes have been paid. That is what is covered under subsection 5. So for the purpose of subsection 5, the term eligible duties and taxes will cover all these taxes in respect of inputs and input services which are received on or after the appointed date. This is explanation 2. Now, the dispute was going on whether education cess credit can be carried forward under transitional provisions or not. Litigation was going on, but the government's intention was not to allow the benefit of carry forward of the education cess. Whatever may be the reason, because these are all cesses which are levied for a particular purpose. Earlier, the credit was allowed to be set off only against the same tax. Education cess can be used only for payment of education cess. But under GST, since there is no education cess, they might have thought that the credit balance cannot be carried forward. But that intention has to reflect clearly from the language of section 140. We have seen there is no prohibition whatsoever to carry forward the balance of education cess under section 140. So government wanted to do the damage control. So what is the route available? They have a very time-tested route, making a retrospective amendment. So by virtue of GST Amendment Act 2018, they wanted to make certain retrospective amendments in section 140 so as to not to allow carry forward the balance of education cess, secondary education cess, and Krish Kalyan cess. This was the purpose of this particular amendment. Section 28 of this Amendment Act, section 28, it's not 128, it's section 128 of the Amendment Act made lot of amendments with the retrospective effect from 1/7/2017. What are those amendments? They added the word eligible duties in section 140, subsection 1. We'll just go back. See, in subsection 1, the word eligible duties was added. Earlier, it was a registered person other than a person opting to pay tax under section 10 shall be entitled to take in his electronic credit ledger the amount of SENVAT credit carried forward. So SENVAT credit carried forward will include even education cess also. So they wanted to restrict it. So they added the word of eligible duties under subsection 1. So this is one amendment which they have made through the Amendment Act, section 28. We'll go back. So the term eligible duties was inserted in subsection 1 of section 140. This is one amendment. Second, in explanation 1, they added subsection 1. We will go back. See, explanation 1 was applicable only for subsection 3, 4, 6. What is explanation 1? It's defined the term eligible duties. So there they added subsection 1 also. So what will happen? Wherever the word eligible duties is used, now under subsection 1 also the term eligible duty is added. So to understand what is eligible duty, we have to come to explanation 1. So explanation 1 will now apply for subsection 1 also. So in explanation 1, they added subsection 1. Similarly, in subsection 2 also, by virtue of clause B1 of section 28 of the GST Amendment Act, subsection 1 was also added in explanation 1. And AED-TTA was omitted. That is not relevant for our discussion today. Similarly, in explanation 2 also, subsection 1 was added. What is explanation 2? Explanation 2 defined eligible duties and taxes. Originally, it was used only for the purpose of subsection 5. Now they have added subsection 1 also in this particular explanation. The term is eligible duties and taxes. Explanation 2 defines eligible duties and taxes. Wherever the term eligible duties and taxes is used, the meaning will be as per this particular explanation. Originally, this was applicable only for subsection 5. Now it is added for subsection 1 is also added in the explanation. This is another retrospective amendment. Then they added another new explanation, explanation 3. For removal of doubts, it is hereby clarified that the expression eligible duties and taxes excludes any cess which has not been specified in explanation 1 or explanation 2, and any cess which is collected as additional duty of customs. That is not relevant. See, now they are going one step ahead. They are saying for removal of doubts, that expression eligible duties and taxes. Note the terms very carefully. We are concerned with the two terms, eligible duties and taxes. So explanation 3 says the expression eligible duties and taxes excludes any cess which has not been specified in explanation 1 or explanation 2. Under explanation 1 and explanation 2, education cess, secondary education cess, KK cess, these are not covered at all. We have seen. What is explanation 1? AED, GSI, CVD, SAD, excise duty, NCCD. What is explanation 2? AED, GSI, CVD, SAD, excise duty, NCCD, service tax. So it doesn't cover education cess or secondary education cess or Krish Kalyan cess. Now, explanation 3 says the expression eligible duties and taxes will not include any cess which is not mentioned in explanation 1 or 2. So government thought by virtue of all these amendments, the purpose is achieved. What is the purpose? Education cess balance, secondary education cess balance, KK cess balance should not be allowed to be carried forward under section 141. That is the purpose for which this retrospective amendment has been done. But whether this amendment is proper, whether this amendment is sufficient to achieve the intended purpose of the government, we have to see very carefully. So what has happened? After this amendment act was passed, the government realized they committed a mistake. So how to avoid the mischief of that particular mistake? So they have found out another way. Whatever mistake we have committed in amending this particular provision, those provisions alone, we will not notify. Let it be there in the act. But giving the date of effect to this particular amendment is in the hands of the government executive. They have to issue a notification from which date this amendment will become effective. While doing so, we will not give effect to those provisions where a mistake has been committed. What is the mistake? We have to see. Now, this is a notification. Notification 2/2019, Central Tax, dated 29/1/2019. So through this notification, various provisions of the GST Amendment Act 2018 have been brought into force with effect from 1st February 2019. This notification is to fix the appointed date from which the Amendment Act will come into effect. There, they have made certain exclusions. What is relevant for our purpose today is, if you see that, except subclass 1 of class B and subclass 1 of class C of section 28. So, Amendment Act section 28, subclass 1 of class B and subclass 1 of class C has not been notified. Will it ever be notified? It will not be notified at all. What is the reason? So we have to see very carefully. We will just go back. What is subclass 1 of class B? Adding subsection 1 in explanation 1. What is subclass 1 of class C of section 28 of Amendment Act? Adding subsection 1 in explanation 2. If these amendments were put into effect, what will happen? We have to see what will happen. See, what is explanation 1? Explanation 1 defines eligible duties for the purpose of section 346. What is subsection 346? 3 gives credit for the inputs lying in stock for those people who are not eligible to take that credit. Subsection 4 is a combination of 1 and 4. Wherever dutiable products or taxable services are done, what is the balance in my last return? I will carry forward. Wherever I am manufacturing exempted goods and exempted services, whatever inputs pertaining to that lying in stock, I can take the credit. That is subsection 4. Subsection 6 deals with certain specified persons who are not eligible to take input credit. under the old law, now they are eligible. So explanation 1 lists down various duties paid in respect of the inputs lying in stock. Please note it very carefully. Explanation 1 defines what is eligible duties. Eligible duties means 1, 2, 3, 4, 5, 6. 4 is again removed. Forget 4. 1, 2, 3, 5, and 6. In respect of the inputs held in stock, inputs contained in semi-finished goods, and inputs contained in finished goods. So, if subsection 1 is also included in explanation 1, what will happen? Subsection 1 allows credit of the balance lying in the last return. See, credit taking is one aspect. The credit taken and the balance lying in the return will have no correlation with the stock. I might have used all the stock of my inputs, but still I may have balance of credit. Vice versa. I may not have any balance of credit at all in my return. I would have used all the credit, but still I may have some stock of inputs. So various permutations and combinations are possible. The point is the stock lying on a particular date has got no relevance to the balance of credit on that particular day. There is no correlation at all. So if subsection 1 is also included in explanation 1, what will happen? I may have a balance of Senvat credit. Today, on 30th June 2017, I have 10 lakhs worth of credit. I have 10 lakhs balance in my Senvat credit account. Central excise duty or service tax or whatever it is, I have 10 lakhs balance. But I don't have any balance of input on my hand. All input I have used, manufactured and cleared everything. I don't have any input stock. If this amendment was put into effect, I cannot carry forward the 10 lakhs balance credit at all, because even though section 141 allows eligible duties to be carried forward, the term eligible duties is defined in explanation 1 that refers only to the credit to the extent of inputs lying in stock. Let us take, I have a 10 lakhs balance on 30th June 2017 in my Senvat credit account under the head excise duty. But I have only small quantity of inputs in stock on 30th June 2017. The credit attributable to the inputs in stock on 1st July 2017 is say 1,000 rupees. So I can carry forward only 1,000 rupees. Even though I have a balance in my ER1 return 10 lakhs, I can carry forward only 1,000 rupees. So that will be the calamity. If this amendment of including subsection 1 in explanation 1 was put into effect, the entire balance of excise duty credit and service tax credit available in the ER1 return or Rs.3.83 return cannot be carried forward. So it is a mistake. This particular amendment was a mistake. So it was not notified. Similarly, explanation 2. Here also subsection 1 was added by subclass 1 of class C of section 28 of the Amendment Act. If that amendment was put into effect, what will happen? This definition will apply for 140 subsection 1 also. What is this definition? Eligible duties and taxes. It will include only 1, 2, 3, 5, 6, and 7 in respect of inputs and input services received on or after the appointed day. Because subsection 5 deals with transit, input and input services in transit. Excise duty was paid or service tax was paid, but that input or input service was received after 1/7/2017. How to take credit? Subsection 5 provides for it. For that purpose, there is a definition of eligible duties and taxes. So that is referring to the inputs and input services received on or after appointed day. If you apply this definition to section 141, no balance in the last return can be carried forward. So whatever is the balance lying in my return on 30th June 2017, inputs and input services were already received. So if you apply explanation 2 to subsection 1 of section 140, no credit can be carried forward. This is another mistake. These two mistakes committed in the Amendment Act were never notified. Never notified. It will not be notified also. It will not be notified also. But government thought still they can achieve the purpose. What is the purpose? The purpose is not to allow the credit of education cess, secondary education cess and critical cess lying in the last return as on 30th June 2017. That is the purpose. How they wanted to achieve the purpose? They thought explanation 3 is sufficient. Explanation 3 is an omnibus provision. It says the term eligible duties and taxes will not cover any cesses which are not mentioned in explanation 1 or 2. In explanation 1 and 2, education cess is not at all mentioned. Secondary education cess and KK cess is not at all mentioned. So it will never become an eligible duty and taxes. So you cannot carry forward. But is it correct? Unfortunately or fortunately, this is also a not correct interpretation. And that is where the decision of the Bombay High Court recently in Godrej Boyce case is coming about. So we will just read the relevant para of the judgment. Perusal of the impugned to show cause notice would reveal assumption of jurisdiction by the respondent number 3 based on introduction of explanation 3 to section 140, read with explanation 1 and 2 thereof, without showing application of mind as to whether the amended explanation 1 and 2 have been made operational or not, as well as whether explanation 3 would at all apply to subsection 1 of section 140. There could have been little reason for us to interfere if assumption of jurisdiction by the respondent number 3 on the ground appearing from the impugned to show cause notice were shown to be defensible with reference to those provisions of law which have become operational by due exercise of power in terms of subsection 2 of section 1 of the amending act. That is the power to give the effective date. Even otherwise, it has not been shown to us that upon introduction of explanation 3 of section 140, read with partly unamended explanation 1 and 2 thereof, the respondent 3 did have the jurisdiction to issue the impugned to show cause notice. For the reasons as aforesaid, we hold that the present case is one where the impugned to show cause notice suffers from an error going to the root of the jurisdiction of the respondent number 3 in assuming jurisdiction and is accordingly indefensible and liable to be set aside. We order accordingly. It is, however, made clear that if the respondent number 3 has reason to believe that the action proposed in the show cause notice could be saved even without the amendment in explanation 1 and 2 of section 140 having been brought into force or on grounds other than the one assigned therein, he shall be at liberty to issue a fresh show cause notice to the petitioner, and if such notice is issued, the petitioner will be free to respond to the same and take all possible defenses. Now, this is what the Bombay High Court has observed. Still, we have to understand a little more. What the Bombay High Court has said was, the amendment to explanation 1 and 2 have not been notified. Why it has not been notified, we have already seen in detail. So if at all it was notified, it will lead to very disastrous result. No balance in credit as per the last return can be carried forward. So we have to forget those amendments. It will never be notified. So now section 141 uses the expression eligible duties. That has been given effect. So as per section 140 subsection 1, the Senvat credit of eligible duties as per the last return can be carried forward. Now, there is a definition for the word eligible duties under explanation 1, but that is only for subsection 3, 4 and 6. That is specifically only for subsection 3, 4 and 6. So, the definition of eligible duties under explanation 1 cannot be applied for subsection 1. Cannot be applied for subsection 1. Similarly, there is another expression, explanation 2, that uses eligible duties and taxes. That expression is used only in subsection 5, not in subsection 1. So that second explanation is not at all relevant for us. What about explanation 3? Explanation 3 defines what is eligible duties and taxes. The term eligible duties and taxes is used only in subsection 5. So for subsection 1, explanation 3 is also not relevant. So whatever the government did to disallow carrying forward the balance of education cess and secondary education and KKs, whatever retrospective amendments they have done, they are not sufficient. There are a lot of mistakes in doing such amendments. So Despite all those amendments, whether they have come into force or not come into force, whether they are going to come into force or not going to come into force, as of today, as the legal provisions stand, there is no restriction to carry forward the balance of education cess and the secondary education cess as per the amended provisions. This is what we could gather from the judgment of the Bombay High Court now. So now what the government is going to do? Are they going to do one more retrospective amendment and correct all the mistakes? Who else on the earth can have this luxury? You can commit whatever mistakes and you can correct all the mistakes retrospectively. Is it not a luxury? How much amount is going to be in balance? Why not? Those balance can be allowed to be carried forward and used for the payment of purpose of GST. The government, I expect the government to be a little more generous, and whatever has happened. Please allow the carry forward of the education cess and the secondary education cess. And thank you all for listening.